Remember this guy, Connor Bowman? You know, he's the poison control specialist, former poison control specialist, accused of, you guessed it, poisoning his wife. Now, I remember it because it's one of the first poisoning murder cases I've covered here at Law&Crime. Well, he's been in jail since his arrest in October of 2023, but now a judge is ruling some of the evidence used in the case against him was taken unconstitutionally. I'm Elizabeth Millner with Law&Crime. Connor Bowman is charged with first and second-degree murder for the death of his wife, Betty Bowman. He hasn't gone on trial for his wife's murder just yet, but according to the judge's ruling, the jury might not see some of the evidence anyway. Just last month, Connor Bowman's defense attorneys filed a lot of court paperwork to suppress a bunch of evidence. Essentially, they argue the search warrants used to obtain evidence lacked specificity, violated doctor-patient privilege, contained First Amendment material, and were overbroad. The defense claims police didn't meet certain standards to seize certain items with the search warrants. So, for example, the defense claims investigators were rummaging through electronic devices, and some of the items seized, like documents referencing death and/or research involving substances that can result in death, were taken from a practicing physician's home. The defense alleges some of the search also violated medical privilege because both Connor and his wife were medical professionals. Betty was a pharmacist, Connor worked as a poison control specialist. So the defense says the warrants weren't specific, and there should have been limitations on what was seized. So let's go back a bit to August of 2023. So this makes a lot more sense. That's when Connor's wife Betty was rushed to a hospital for severe intestinal issues and severe dehydration. Just 4 days after being admitted, she died. Betty, by all accounts, was healthy and young. She was only 32 years old. So how could a healthy 32-year-old just die out of nowhere? Well, it's because she likely didn't know she was allegedly being poisoned by her husband. According to his criminal complaint, Connor made searches on the web about colchicine, a medication used to treat gout, and he searched how to buy it. And surprise, surprise, the medical examiner ruled Betty's cause of death was due to toxic effects of colchicine. Betty didn't have gout, nor was she prescribed the medication. But here's the thing. Remember how I said Connor worked as a poison control specialist? Well, the University of Kansas did employ him to do just that. But university officials told police Connor had no reason to be researching colchicine as a part of his work for them. But it was Betty's friends that seemingly helped piece it all together. Betty started feeling sick after she was given a smoothie by her husband. According to the criminal complaint, Betty described the smoothie as bitter and salty, so nothing like a smoothie would actually taste. A friend even told police it was strange for Connor to make his wife a smoothie in the first place because he never made anything for anybody. Even after Betty died, friends of the Bowmans say Connor was quick to move on. He had another woman over at his apartment, took the photos of Betty down, and he told his friends he was getting $500,000 in life insurance. Well, he actually got $450,000 after police found a bank deposit receipt in his home. So if you're curious about a motive, it might be the money, plus add in that Connor and Betty were reportedly in an open relationship. The two said they wouldn't get attached to their other partners, but friends say Connor did just that. So when Betty confronted him, allegedly, she suggested, let's go ahead and just divorce. And that's not all. According to the search warrants that's called into question later, Connor searched for lethal doses of colchicine, specifically the effects it would have on someone weighing 120 pounds. And if you guessed if that's Betty's weight, you're right. He also made searches like internet browsing history, can it be used in court, delete Amazon data, police. Plus, Connor didn't even want to have an autopsy done on his wife. So you can see how he became suspect number one. But you can also see why the defense wants those searches out. Now, as far as the state's argument, they want the evidence from his electronic devices to be used in his trial. They argue they had information that suggested Connor was looking through Betty's medical records after her death. They also point out that Connor never received a call about working on colchicine while working as a poison control specialist, meaning why would he search about this particular drug if it wasn't for work? Yet it was the very drug that killed his wife. So the judge had the final say, seemingly issuing a huge blow, though, to the prosecution's case. The judge ruled the data showing the ownership of the device can be used, but here's what can't be used, citing it's unconstitutional. Media, including text, emails, photographs, notes, and/or audio files and videos, including media regarding toxic, hazardous, controlled substances, financial matters, divorce, and/or personal relationship information, text messages/communications, including conversations about toxic, hazardous, controlled substances, financial matters, divorce, and/or personal relationship information, web internet browsing history, including searches, websites, articles, etc. about toxic, hazardous, controlled substances, financial matters, divorce, and/or personal relationship information. Data may be found in either the native application installed on the electronic devices or other third-party applications downloaded to the devices. In legalese, it means the judge believes the language used in the warrants was too broad, and the language used in the second warrant should have been more specific. But again, a huge blow for the state. So how will they bounce from it? I mean, there's still a lot of circumstantial evidence. And there's a lot of time too, because as of this recording, no trial date has been put on the calendar. I'm joined now by criminal defense attorney Sky Lazaro. Sky, thank you so much for joining me today. Before we get into the judge's ruling, what's your take on this whole case as a whole? Connor Bowman is accused of poisoning his wife with gout medication that was allegedly put in her smoothie of all drinks.
These poison cases are always, I think, captivating in terms of, they grab people's attention, but they're hard cases a lot of times from a legal and forensic standpoint because the prosecution really has to show that, someone obtained something, some sort of drug, and somehow administered it to the person causing their death. So I think there's a lot that goes into these cases and just I think the idea of poisoning is, that's something that, if someone did, takes a lot of thinking, a lot of planning, and a lot of follow through. This isn't a crime of passion, like I got mad and shot someone, in an argument. This is, something that takes some planning and follow through. And, I think that says a lot about the people convicted of these crimes.
Oh yeah, and just going off of that point, it does seem like a very meticulous and well planned out murder, if the allegations are true. And Connor himself even made some disturbing searches prior to his wife's death, like internet browsing history, can it be used in court? Delete Amazon data, police, and then he was comparing the lethal doses of colchicine to his wife's weight. Is that all just a coincidence, or do you think that this was signs right there that he had planned this out?
I think unless he was doing that for some sort of medical reason to assist her if she was taking these treatments already, it seems like a very odd thing to be Google searching. Now, as we learn from the judge's rulings, a lot of that stuff is not going to come in, which is really helpful to the defense and probably really harmful to the prosecution's case.
Yeah, and just going into that, because that actually brings me to my next question. They do argue that the search warrants were unconstitutional. Investigators collected 14 electronic devices plus an iPad. Now, some of the evidence can be used, but a good chunk of it seems to be stricken from record, specifically citing the following as unconstitutional. And bear with me as I get through the judge's ruling. Media, including text, emails, photographs, notes, and/or audio files and videos, including media regarding toxic slash hazardous slash controlled substances, financial matters, divorce, and/or personal relationship information, text messages slash communication, including conversations about toxic, hazardous, controlled substances, financial matters, divorce, and/or personal relationship information, web slash internet browsing history, including searches, websites, articles, etc., about toxic, hazardous, controlled substances, financial matters, divorce, and/or personal relationship information. Data may be found in either the native application installed on the electronic devices or third-party applications downloaded to the devices. Now, that was a whole mouthful, but to me, it seems like that is a lot of evidence to be taken out or be stricken. What are your thoughts on just the overwhelming amount
Yeah,
of stuff that they can't use?
this is a huge win for the defense. Huge. Because if you think about all those things that have been excluded, it goes to motive, planning, premeditation, all those things that, if a jury hears, they're really going to think he probably did it and is a bad guy because otherwise, why else? What is the other explanation for that? The financial stuff, did he allegedly kill her because, of life insurance or, whatever the theory is. This really, I think, is really harmful to the prosecution because all a jury is going to hear essentially is that he used his computer between these times because that's what the judge is allowing in, but none of this other information that would show, his opportunity, a motive, a plan, obtaining it, how to administer it in fatal levels. So I think this is, if you're the defense, you're pretty you're, you know, there's other evidence obviously in this case, but keeping this out is a huge win for them.
Yeah, and I could even describe them probably as giddy that the judge made this ruling as well too. Now, I do want to ask you, can witnesses for the prosecution, can they still get on the stand under this ruling and testify possibly about the couple's almost divorce and their personal relationship, possibly finance issues? Can witnesses out of their mouth kind of say that, or will that not be included as well too?
No, absolutely. So anybody with firsthand knowledge, if the prosecution can show it's relevant to the case, those people can testify. So the judge didn't exclude, you know, broad categories of information. He just excluded what was found on the devices. And, what's helpful or would be really helpful to the prosecution is, essentially they can, if they can show this is his computer, this is his login, it really is almost like saying, he did it, or it is saying he did it. These are his actions. But certainly other witnesses who have observed things or have personal information, or, they can even go so far a lot of times, unless the judge specifically excludes it, to testify about the things the defendant has said to them. So if he made comments to other people about obtaining things or had a discussion about these types of drugs or how to administer them, that is probably going to come in. It's just strictly the information found on the computer or the other electronic devices that's excluded.
And you sum that up perfectly as well too, because I can also imagine that a witness or some of Betty's friends who had testified, or at least told police that Betty had been talking about just the taste of that smoothie, how it didn't taste right, it tasted bitter and salty. I can imagine that the prosecution is definitely going to want to put those types of witnesses on the stand. And Connor, he's been behind bars since 2023, the fall of 2023. Obviously, now we're in 2025. Are you surprised this case hasn't gone to trial yet?
Not really. We're not quite at 2 years. A case, usually cases that involve complex matters like this and very serious charges, it's unlikely, I think, for even when they're held in custody for these cases to get to trial until about a two year mark. I would say that's probably pretty average to be trying a case such as this because of everything that needs to go into it, all the pretrial litigation, investigations, all of those sorts of things that the defense is doing and the state's doing. And sometimes the reality is for the defense side, aging these cases helps because, when things first happen, there's a lot of shock, there's a lot of emotions, even for just people in the community. And as time goes on, there's still people who may feel strongly about it and are going to, but I think as a kind of broad overarching, how does the community feel? Those things kind of start to dissipate because other things have happened. There's other cases, there's other news stories. So it kind of calms everything down. And you want to, when you try a case like this, that's probably going to evoke a lot of emotion, just, based on the allegations and some of the testimony that's going to come in, and someone's dead. I mean, it's tragic, you know you want you kind of want everything to be calmed down, not in sort of this like hyper frenzy. You really want it to be about the law and the facts and the evidence that comes in so that you can, I hate to say it from a defense side, but you kind of want to, de-escalate the emotional side of things.
And also, for a witness's standpoint too, their memory could get a little fuzzy the longer that it
Hmm.
holds out as well too. So I can see how it does work in the defense's favor. And in terms of just defending a client that's accused of doing this, how hard is it to defend poisoning cases, especially given that it seems like there is circumstantial evidence, but then some of the evidence, has been tossed out come trial. But in terms of just defending a client accused of poisoning, when there really isn't like another person that investigators have said is a suspect, how hard is it to be a defense attorney, especially to be Connor Bowman's potential defense attorney? Not that you are, but and if you
Right.
were in their shoes.
Yeah, defending poison cases is often very interesting because there's so much that we are never going to know about this case, right? There's probably a lot of underlying things that he's talked with his defense counsel about, that they're aware of, that the state's aware of, that may never even be part of the jury trial, right? So it's always interesting, when we look at these cases and what we read about them in the media and see, and then when you're involved in the flip side of what's actually out there, what the state can actually show, even with circumstantial evidence, but is generally vastly different. And, he may have an entirely other theory and probably does, about what happened or what made her sick. Not knowing all the facts, it's hard to say like how good the prosecution's case is, but certainly in a case like this where a lot of it's circumstantial, keeping out a lot of the stuff that was done on his computer is going to be really helpful to his case, I think.
And what other types of uphill battles are the prosecution facing right now? Because obviously it doesn't seem right now that it's surely a slam dunk case for them.
Yeah, I think that's always the hard part about these is a lot of times, unless they've made admissions or a defendant's made admissions or something like that, these are generally not slam dunk cases because you're probably going to have competing expert testimony about the cause of death, the levels, how things, different people metabolize different drugs, whether or not she had any other medical conditions going on that could have contributed to this. But really what it comes down to is the prosecution has to prove that there was a murder. And that is sometimes hard in poisoning cases where, maybe there's maybe possible other explanations. It was an accident. It was I took the wrong drug. It was, sometimes self-induced. And I'm not saying that in this case, certainly, but that has come up in other cases. So they have to prove there was a murder to start with, and then they have to prove that the defendant got the drugs and, intentionally and knowingly gave her a lethal dose. Now, I think in this case, he's also charged with negligent homicide, which is a reckless standpoint. So it wouldn't have to be knowingly. It could just be, it was an accident and he should have known better. So they've charged him with both of those. I think probably because they're aware that they may have some evidentiary problems in proving, a premeditated murder.
And it'll be interesting to see how this all continues to unfold. Sky Lazaro, I want to thank you so much for your insight into this. Before we sign you off, though, do you think that Connor Bowman will get his trial on the calendar sometime at least this year?
I think it's certainly a possibility, depending on, where they're at in terms of pretrial motions. But I would say, I think it'd be reasonable to see this case tried later this year, the beginning of next year.
And we've just been anxiously waiting for that trial to get onto the calendar. I've been covering this case since 2023. It's just wild just how we still haven't made a trial just yet. Again, Sky Lazaro, thank you so much for your time and your insight into this. I really appreciate it.
Thanks for having me.
Again, no trial date just yet on the calendar. So for now, Connor Bowman remains locked up in the Olmsted County Adult Detention Center in Minnesota. Reporting for Law and Crime, I'm Elizabeth Millner.